Hello, this is attorney Harold Weiser with the Weiser Law Firm. Today we're going to talk a little bit about do-it-yourself divorces in the state of Louisiana. A lot of people want to know, since we do an excessive amount of divorces, why talk about do-it-yourself? Well, the main reason is because many of our clients actually call us after attempting to do-it-yourself divorces. They may buy different papers or different forms on various websites, some of which have now been shut down by the state, or they refuse to offer these particular forms anymore because Louisiana is a civil law state, and as a civil law state, our forms are slightly different than the forms in the state of Texas or the forms that you'd use in Mississippi or Florida or something of that nature. And it's just because our law is a little different. But the simple thing to say here would be that you would want to get the forms preferably from the courthouse. Those are the forms that those judges are mostly going to accept. Those are the forms that they're used to, first of all, and those are the forms that they've set out specifically for you to use. So I wouldn't find any reason why a person wouldn't want to at least attempt to get the forms at the courthouse. But that brings me to the first point, which is basically location, location, location when it comes to courthouses and trying to do it yourself with these own types of divorces. Each courthouse has their own type of forms that they want you to use. So if one were to bring the forms from, let's say, Orleans Parish to Baton Rouge may not accept those particular forms. And likewise, if you're in Alexandria and you're trying to file a divorce in Lafayette with those particular same forms. So be cognizant of your location. But we'll come back to that in a few minutes. First off, what are the requirements for a divorce in the state of Louisiana? Well, if you haven't looked it up yet, you have to be separated for 180 days if you have no children that have been born since you've gotten married until the point that you are separating. And you want a good separation period of 180 days first before filing if you're trying to get it done the least expensive way possible. But be aware that does not take into account child custody, child support, spousal support, property dissolution, or any other matters that may come along with divorce, as well as pension retirements and things of that nature. So be cognizant when you're separated from your spouse and want to wait the 180 days because you may be losing out on other rights that you could have facilitated in this wait period, because you haven't actually filed for divorce and you're technically not legally separated. So one big thing is, can I go and date other people? And legally speaking, no, because if you're caught and you're separated but not legally separated or haven't filed for divorce, then you've indicated to no one officially that you're moving on from that relationship on to another point in time. And if you have minor children, and the key is minor, if they're over the age of 18, then the 180 days is sufficient. You've waited out your time period. The children are not of any consequence to the court in that fashion, and they know they don't have to deal with child support, and they know they're not going to have to deal with child custody, which are pretty big facets of divorce. But if you have minor children that were born after you got married and are under the age of 18 at the point that you're about to file this divorce, you're going to have to wait 365 days, or simply put, a year. But that's the requirements to file this type of divorce. And the one that I'm speaking of is called a Louisiana Code of Civil Procedure, Louisiana Civil Code Article 103 divorce, not the procedure version, but it is the one where you've been separated and now you're filing for divorce and you want to get this concluded as quickly as possible. That's the first requirement. The other ones are pretty simplistic. My wife or my husband or my spouse will sign a one-page document specifying that it's okay to waive delays in a divorce, or I've been given a copy of the paper of the divorce. You can go ahead and have them served, but it's going to make the time period last longer. Typically 15 days if they're in state, 30 days if they're out of state. And then there's all kinds of delays for getting the service back to the court, getting the affidavit of service, etc., etc. It's a lot easier to get them to sign this one-page form. And that would, of course, mean that your spouse is okay with your filing divorce, or at least is aware that, hey, I'm just filing this divorce. The other simplistic things are that your spouse isn't deployed on the active military. We don't want someone that's deployed in Iraq or Afghanistan having their spouse rushing off and getting divorced, and they can't make it to any divorce proceedings. They can't do anything about it, and they barely have any knowledge of it, and they're halfway around the world. But if they're working out of the Naval Reserve or in the Reserve National Guard or something of that nature, then it's not too excessively complicated unless they're on a military base, and that's only for service. We definitely don't want pregnancy. Pregnancy in a divorce is complicated, and the reason is we'll get a phone call, hey, I'm 7 months pregnant and I want to file for divorce immediately. We need to get this rushed. Well, if you separated for your time period, 180 days, and you're filing for this divorce, well, technically you can get divorced. We have to write in the paperwork that, yes, I am pregnant, but the child isn't here. And it complicates matters because in our law, if the child is born up to 9 months after the divorce, the father is legally presumed to be the husband or the spouse at the time of the divorce. So that does complicate matters, but most of the time I have yet to see that come up as an issue. The issue comes if they're pregnant and you don't know when the date of the child that is going to be born happens, or you're trying to rush the divorce and then the child's born. Well, in that instance, the divorce filing really is no good because you already declared that I'm pregnant, but we don't have any children at this time, and we haven't waited out our allotted amount of days. So that complicates things. So we preferably don't like pregnancy, but a lot of people call us for that. The other one is we don't want adoption proceedings. This is the attempt to find a child, and generally if you're married on the adoption proceedings, you're always going to put all of this adoption information on there, and of your spouse, of your job, etc., etc. Well, you don't want to have to go pull that adoption proceeding away from someone because it complicates matters. It makes it hard on trying to find a parent for this adopted child, and it's not good to try to get divorced during that one. And one of the last elements is, did I enter into a covenant marriage? Everyone asks, well, what is a covenant marriage? And we have to tell them that a covenant marriage, simply put, is a type of marriage in Louisiana and only a few other states that requires people to do premarital counseling and wait a longer period of time to get married. But don't worry, if you got a covenant marriage, you will know it, because the average person fills out the regular marriage certificate for their marriage license and gets a regular marriage. The ones that give it a covenant marriage, they know that they're entering into this covenant marriage because it requires twice the amount of time to get divorced. It makes it very hard and complicated to get a basic divorce because of this covenant marriage. And if you have children, it becomes even more complicated. But most people don't enter into that, and you would know if you did. One thing that our office always has issues with is whether or not the person is incarcerated in jail. Now, why is that a problem? It's a problem because if a person's in jail, how do they sign their form? Well, some jails have a public notary that go around, and when you have a public notary that goes around the jail, yes, they can get the form signed. But we don't know when they're going around to have this. Also, some jails don't have public notaries. Some jails don't have access to people, and We aren't driving to whatever Hunt Correctional Facility or Angola Correctional Facility to go in, meet the current inmate at the time, to have them sign a document and to notarize it in front of us. It's just not worth the time and effort to do that. So we try to stay away from the jails, but sometimes we have to file and we have to do service, and we've run into a lot of problems on the jail facility not getting them served, not having notification proper, and ICE has become a really big issue because many of these detention facilities are private, and we don't want to have issues with the private companies that don't want to accept service on behalf of the inmates that are under their control, but nor do they allow private process servers or our mail options to be valid because they're detaining a person. So jails can be complicated. So be cognizant of that if you're trying to file your do-it-yourself divorce. The basic procedure of filing a divorce, if your divorce is simple, is not going to be too complicated. Number one, you file the divorce, make sure that you have everything that we've talked about listed. I did not mention some of the more complicated things of venue and jurisdiction, but simply put, wherever one of the spouses lives, if you live in Wichita Parish, then you can file in Wichita Parish. If the other spouse lives in St. Tammany Parish, you can file in St. Tammany Parish, etc., etc. So any parish that someone lives in. And you also can file where the marriage took place, if both parties have moved. But if you have children, or you have ancillary issues or property or things of that nature, you're going to want to file where you live, because it's going to be much more convenient for you to go back and forth to that courthouse as opposed to traveling to get something accomplished. So file your divorce. The next portion is to pay the court cost. And this is somewhere where location comes in. Different parishes charge different fees. St. Tammany Parish, for example, does not charge a lot to file the basic divorce, but if you have custody or something that's added on top of that, they become one of the most expensive divorce places in the state. Right now, off the top, Jefferson Parish is the most expensive. They're $400 just to file a divorce, and then charge other kind of fees like copies and things of that nature afterwards. So just be cognizant of having your money ready to pay the clerk of court's office and the sheriff if you have to do service. But you can save a few dollars by having what we call a waiver form, or the affidavit saying that I've been given a copy of the papers and I waive delays. Most documents have to be signed in front of a public notary, but that's simply to prove who the person signing the document is. So always try to have your notary or a notary available to stamp your documentation. So once service and this waiver form is filed with the court, the next process is to get what we call a preliminary default, or what you can commonly refer to as basically a preliminary divorce. I filed my divorce, the other spouse has been notified either by service or waiver, and I'm here to provide that to the court and to get a preliminary divorce signed. In that instance, if the court has forms, you could walk that in, write your particular information down on it, and the judge needs to sign and order it. After that, you're almost done. You have 3 days that you have to wait, and then you can file your motion to confirm the default judgment without a hearing. You can file your basic affidavit, and that's the person filing for divorce specifies that they're not in the military, that there's no pregnancy, there's no adoption, and there's no covenant marriage, which we already talked about. It's a basic affidavit. And you also want to file your certificate that's required to check. The different clerks' websites have different certificates, but that means that all the steps have been followed. This is a 103 article divorce. So-and-so was served or signed a waiver on this date. It was filed in the court on this date. And you want to have these certificates, and the clerk of court will probably stamp on there that all expenses are paid, or that service was done, or that no answer has been filed. That's assuming that your spouse doesn't want to fight you, but if they do file something, all of this procedure basically comes to an end. So you have that together, and then finally you just want your judgment of divorce, and you have it typed out or written out or whatever form that you have, and it says, I hereby want to be granted an absolute divorce from this person for life, and you have your name on there. Some jurisdictions allow the spouse that filed to return to the maiden name, and now some jurisdictions are charging for that additional step. And again, it depends on which location. Location determines the price. Location determines the procedure that you follow. Right now, during COVID, I would not recommend filing in Orleans Parish, for example, as some of the judges are just not available to sign. The clerk's offices are acting at a shorter amount of time to get things done, but they're just not there as often. So it really slows down the process, and other parishes are moving as normal. So be cognizant of that. Also, one last thing to consider is which judge do you wind up with, and that's something that you don't know about until after you file in the courthouse. Some judges are more readily available, and some judges aren't. Some judges, like a couple of judges in some of the Bayou area parishes down in Lafayette and Terrebonne specifically, they want additional witnesses on top of the divorce. So you just have to be cognizant of some of those problems that you run into. But if all is good and all the fees are paid, you will have your divorce, and you got to do it yourself, and you didn't have any complications. And like some people, you can move on into planning out your next wedding. But if you run into any complications or problems, think of our office. It's the Weiser Law Firm on Canal Street in New Orleans, and we'd be happy to give you a quick consultation on trying to resolve the issue or see what we can do to try to save you some fees and not having to refile. Thank you.